no objection?
No objection.
No objection to the defense.
All right, thank you. This is People of the State of Michigan versus Rashad Trice, docket number 23-855FC. This is the time set for sentencing. Mr. Trice, you were convicted of first-degree premeditated murder, a felony punishable by life with no possibility of parole, and first-degree criminal sexual conduct, a felony punishable by life for any term of years. The prosecutor is also proceeding against you as a habitual fourth offender. You have the right to an attorney, of course, and you are represented today by Mr. Watson, who's been granted permission to remain seated at counsel table due to a physical complication. And before I go further, Mr. Trice, I am required to get your consent to proceed with the sentencing remotely instead of bringing you here to the courtroom. Do you agree with this?
Yes, Your Honor.
Thank you. And first matter of business is, Mr. Watson, have you had an opportunity to review the pre-sentence report with your client?
Reviewed the pre-sentence investigation report with my client and discussed some other things within the preparation for today's sentencing. I am now reviewing SIR that was presented only yesterday.
Okay, I am going to go through some changes first that I made to the pre-sentence report. On the cover sheet, where it has the basic information about the case, it says current convictions. I added habitual fourth to both the homicide and the CSC. And under plea agreement, where it describes the plea agreement, it said the prosecutor was dismissing the habitual fourth. I crossed that off, and I added it after the defendant pled guilty to count 2 and count 6 as a habitual fourth offender. Under evaluation and plan, I added that he pled as a habitual fourth offender. Under basic information report, it says somewhere on there it says habitual offender. No, when I changed it to yes. Or maybe it doesn't. I'm just going to add it after they list the offense. So where it says current offense, and it lists first-degree premeditated murder, and I'll put and have fourth, same with the CSC. And then on the convictions, I changed number 16 of 19. It says final charges, count 1, attempt, fleeing and eluding fourth degree, and it lists that as a public safety level H felony. It is a non-scorable misdemeanor. And those are my changes on the report itself. Did you have any other changes, Mr. Watson?
Not after review of pre-sentence investigation body of the report, having reviewed that with Mr. Trice.
All right, and Ms. Russo-Benz, just with respect to the report itself, did you have any other changes?
One change, Your Honor, under its evaluation of plan, page 2, so under adjustment to probation, this would be the narrative from when Mr. Trice was on probation in Livingston County. The narrative indicates in that first paragraph striking his daughter, and then there's a name after that. That name should be stricken. It was actually his girlfriend's daughter. It was actually Wynter in this case that was struck during that incident and that violation of probation. They do have that violation of probation report if the court wishes to see that, but that should be reflected on page 2, as well as page 17 of the pre-sentence report. It indicates that later as well, that it was the same incorrect child that was struck during that
So
violation.
you want me to put Winter's name in there
Yes.
instead? Okay.
Thank you.
For striking. I want to be able to spell it correctly. It's Wynter.
Correct, Your Honor.
Did you have any objection to that change, Mr. Watson?
No, thank you very
Was
much.
that your only one you said?
The only change to the substance of the report, a couple comments on the guidelines, other than that, no changes.
Okay. Mr. Watson, did you have any objections to the scoring of the guidelines? And I did change the habitual no to habitual yes on the guidelines.
Well, thank you very much, Your Honor. I've reviewed people's sentencing memorandum as it relates to the calculation of guidelines and discussed things with the prosecuting attorneys in this case. I can tell you that we have reached an accord as it relates to the scoring as the Attorney General has offered in its guideline calculations. I can tell you those changes if Your Honor wishes.
Well, you know, I made some of my own changes because it won't make a difference, but I
Right.
frankly could not verify. And I asked the probation agent to do an updated scoring based on the information the Assistant Attorney General gave, and we could not verify all of it, but in the end, it really doesn't make a difference. I have now looked at the updated scoring, and I agree with the way that the agent has scored the PRVs. Are we all in agreement with that?
The only concern I had, Your Honor, and it might be my mistake, I had believed that 2 of the resisting obstructing from 2021, June 10th, from Clinton County, we believed those to be pled to misdemeanors, so we thought there should have been 8 misdemeanors other than 6. Ultimately, that only would have changed PRV 5 from 15 to 20 points, raising it from 75 to 80, but it doesn't change the level at all. So if the court prefers to go with those being scored as prior felonies instead, with the writer of the pre-sentence report, it doesn't change the PRVs at all.
Well, I couldn't follow your rendition of the priors because it didn't, there were some that just didn't jive date-wise with what was in the pre-sentence
Okay.
report. So I can tell you that for misdemeanors, I scored number 15 of 19 had 4 scorable misdemeanors in it. And then number 16 of 19 contained 1 scorable misdemeanor. So that makes 5. And then number 18 of 19, or pardon me. Number 16 of 19 has a non-scorable misdemeanor, 1 scorable misdemeanor. So that makes 5 scorable misdemeanors. And then number 18 of 19 has 1 non-scorable misdemeanor. So, I mean,
We would agree to leave the points of PRVs as they are.
okay. And then for the offense variables,
The only changes that I would ask to make, and again, ultimately, it's going to change the total number of points, not the level. It's going to be OB3. I believe it should be 10 and not 5 points for the medical treatment for the lacerations, cuts, and bruises.
Yes, I think 10 is well warranted for OB3. So that does take us then to 215 instead of 205. As you said, though, the range is still a F6, which if you correctly, which this scoring didn't, but if you correctly use the habitual for, it makes it 270 months to 900 months or life.
And of course, I had asked to score OB4, but I know the court had said they could not verify OB4 at 10 points, given what they had in the sentencing memorandum and the pre-sentence report. The only other change is I believe the 450 on the guideline should be 900 to reflect the habitual. But other than that, I think that the guidelines are correct. Thank you, Judge.
Yes, I changed it to 900.
Thank you, Judge.
All right, then I think we've got all of our changes covered. And Ms. Russo-Bennett, there are victim impact statements, correct?
There are, Your Honor. Wynter's grandfather would like to read his own statement and read his son's statement into the record as well. And then I have a couple of statements that I would like to read into the record, if that's okay with you.
Absolutely. With the grandfather?
You want me to go first? Okay. Your Honor, at this time, I'm going to read a statement from Wileen Cannon. This is Wynter's maternal grandmother. Now, you have a copy of this, Your Honor. She did write a statement to you, and she has a statement that she wants read as well for the purposes of being directed to the purposes of the defendant. Your Honor, I would like to express my gratitude for allowing Rashad M. Trice the maximum sentencing possible for the heinous crime that he has committed. I don't believe that my life will ever be the same. It's been just over 1 year, and the hole in my heart is just as big as the day this crime occurred. The loss of my granddaughter, Wynter Ava Mae Cole Smith, was a brilliant, bright, and very affectionate toddler. She was so full of love. Wynter even expressed phrases, "I love you," to her murder. I believe because he was part of her life that she had no choice in choosing. This act of pure evilness Rashad has committed is irreversible in its actions and cannot be forgiven. My granddaughter's life was taken before she had the chance to even know who she was, use the potty, say complete sentences. Rashad took her life like an animal, the same way a four-legged beast takes the young of other wild animals in the jungle. Rashad had prior criminal behavior prior to leading up to Wynter's death that I'm sure you know very well. I believe if the punishment was death penalty for murdering children, perhaps this will help save and spare the lives of other children and adult victims as well. It appears that the majority of repeat criminals are very comfortable going back to jail and prison. Serving life without parole is Michigan's maximum sentence. I believe the death penalty would be a wake-up call to a lot of offenders, perhaps. I really wanted the death penalty for Rashad, but I appreciate the current sentence that he's receiving on this date. Rashad has no business in the outside world for the crime he has committed. He would only destroy more lives if given the opportunity to do so. I feel in my heart that justice has truly been served correctly for him on this day. I could not bear to be there in person. I can't bear to see his face without reliving that tragic date with such horror. I am trying to heal the best way I can because the pain of losing my granddaughter and the way she was taken from us is haunting. I have lost so many nights of sleep, reminded of what he did to my granddaughter and my daughter. Seeing him in person and hearing everything he did to her again, I feel will only slow down the process. So forgive me for not showing up in person and accepting this written statement today. You, Rashad M. Trice, truly deserve the death penalty for maliciously taking the life of Wynter Ava Mae Cole Smith. You say you are a monster, but a monster is just who it is. And don't hide from the sinister things you do and create. You are an evil coward, and you live like a wild animal, so you should feel right at home for the rest of your life. You deserve where you are and where you are going. Wynter did not deserve what you did to her, nor did to her mother. You should never be able to be around decent human beings after what you've done. Rotten hell. Your Honor, at this time I will be reading a statement from Sharon Eddings. This is Wynter's father's, AJ's mother, so paternal grandmother of Wynter. I will give a copy to the court of the full statement. I'll be reading a portion of it. Your Honor, we stand before you today as a family, parents who have suffered an unimaginable loss. Our precious 2-year-old granddaughter, Wynter, was taken from us far too soon, leaving a void in our hearts that will never be filled. The pain of her absence is indescribable, and we are trying to piece together our shattered lives. As parents, we have always strived to raise our children with strong values and a deep sense of responsibility, not just for themselves and their future households, but for their community as well. Together, we worked tirelessly to instill in our children the importance of giving back and being a positive force in the world. I regularly volunteered in the community, sharing my skills and time with local Detroit schools. I dedicated myself to teaching STEM education, showing my son and his classmates how to code, while their father, my husband at the time, volunteered as a coach for Police Athletic League, PAL. We both wanted to ensure that our children and others learn the value of hard work, discipline, and community involvement while being present in their daily lives. We taught our children how to support themselves responsibly, even at a young age. Growing up, they played a lot of sports, and like most kids, they wanted some spending money. But with their busy schedules traveling with sports teams, they didn't have time for traditional jobs. We could have given them money when they played for AAU, but we wanted to teach them how to raise their own. We knew it would mean more to them if we had just given it to them. Myself, AJ, Marquis, and our youngest Jackson would go to Gordon Food Service, buy fundraiser candy bars, and walk around the neighborhood. And the kids would explain why they were raising money. We made homemade pizza and sold slices, spending time with our children and teaching them entrepreneurship, showing them how to make something out of nothing, instead of resorting to harming their communities to make money, just to wear Nikes and Louis Vuitton. Sometimes I would make sausage, egg, and cheese sandwiches in the mornings, which they would sell at the bus stop to raise money for snacks at lunch. We worked very hard to ensure that our children understood the importance of being resourceful, staying focused, and contributing positively to society. We also taught our children the importance of managing their emotions, resolving conflicts peacefully, and knowing when and how to express themselves appropriately, but also when to stand up appropriately. Their father and I supported them in sports, attended their games, and guided them through the challenges of growing up, always emphasizing the values of respect and maturity. That night, when Wynter went missing, I took to social media and the community rallied around us. We are profoundly grateful to everyone who helped us in our search for her. During that time, they helped me locate and reach out to your family, and when I spoke with your uncle, and later your mother, I got a glimpse into the environment you were raised in. When I asked your mother if you could have harmed my granddaughter, her cold, indifferent response shocked me. She showed no concern for Wynter, only for you, as if her son's well-being was the only thing that mattered. She acted like Wynter kidnapped you and was going to kill you. Some people raise their children with love, values, and a sense of community. Others, it seems, simply drag them up to 18 so they can wipe their hands of them without instilling any morals, values, or concerns for others. It's a, quote, me first mentality, a lack of empathy that leads to tragedies like this. You didn't just take Wynter's life that night. You destroyed your future as well. You sold your soul, and if you believe in anything at all, you must know that there is a price to be paid for what you've done, more than just serving time. Wynter was better than you then, and she remains better than you today. She will always be better than you. But for our family, it's time to hold our heads high, catch our breath, and begin the painful process of healing. There is nothing more we can do here. We will let nature take its course and let life unfold as it will. We want to thank the FBI, the multiple police departments, and the state authorities who treated us with dignity and respect. While we have been less than satisfied with the federal prosecuting team, particularly the lack of communication, We are grateful for the kindness shown to our family by the state. Finally, we want to express the deepest thanks to the community that has helped search for Wynter, for the prayers, the kind words, the support we received. We are forever grateful. Thank you, Your Honor, for your time.
And please thank them for their statements. Tell them we all understand why they weren't here in person, and I will take everything they said into account.
Thank you so much, Your Honor. The podium, Your Honor.
Please.
We just need a moment, Your Honor.
Just take your time, sir. Whenever you're ready, sir.
First name, Wynter Smith, Almount. I'm reading the statement on behalf of AJ. I'd like to say I'm so proud of him of going back to school to finish where he left off at. That is something that me and the mother taught our kids, to always finish where you left off at. Don't quit. Quitting and saying I can't was not in our household. It was not in our vocabulary. AJ, I'm sorry, his statement. What I want to say, forget why, you know what you did, why you did it, and why you didn't stop. A sweet, precious life that was going to be whatever she wanted to be, no longer has the opportunity. Why? Because you thought you were something and you weren't. You taking out your mistakes and left my daughter alone. Didn't ever think about yours, but instead focusing on something that didn't need, in other words, that she didn't need you, or she never bothered you. You are a waste of space and never showed aggression towards me. But thinking because you put your hands on women and thinking you and I both are on the same level is crazy. I still remember when you sent inappropriate pictures and videos of your relationship when I didn't even know your name. And add with that, then you had the nerve to text me saying that you are a different person and you wouldn't harm my baby girl. You are a coward and a true definition of I can't say the words here, but whatever these words go in and out can't say the words, your head, these probably the best words you have with passion. Unless I can't say the other words, but in other words, he says, you will never be forgotten or forgiven. And hope you live a long life. Signed, Elmont Smith, Jr. This is for me. So many things to say. The big questions is why. Why was my baby, Wynter, my little angel, used as collateral? Why you hated my son, AJ, so much? We're not supposed to be here today. What was you thinking about that night? You was selfish. You didn't think about your son, which you left behind. You took a little angel away from me. Wynter was my first She was my first blood and only my only grandchild. All I have is memories and images of her first day of going to kindergarten, elementary, middle, freshman day of high school, and graduate from high school to pursue her life. I'm sorry. My thing, I'm sorry. Okay, together. As I've been reading about you, I feel the system should have never let you out from day one with the incident in Moreau. Where was your probation officer? My understanding, 2 weeks before all this happened, you and Wynter's mom got into a fight while Wynter was being held. If the police was called, why you wasn't in jail? I really wish we could have met that November of 2022 when I called and wanted to come get Wynter. Because I feel like you would have seen the kind of person of me and AJ. I tell my kids that it's a small world. You don't know who. And I tell my kids it's a small world. We don't know who. If I knew your name, we would not be here today. Why? The reason why I say I wish I knew your name and you. The reason why I say I wish I knew your name and you knew mine is because I went to school with a couple of your family members. that's all we have to say. But bottom line is, what I heard, people, statements saying a coward, a monster, killer. To me, you're none of that. To me, there's no word that describe you. I learned that you can't hate nobody. I don't hate you, but I hate what you've done. As again, you took somebody special from me, my only grandchild. And as I see you, you only live a quarter of your life. And you have not lived life yet. You only lived a quarter of your life. That's nothing. You still got a long ways to go. And I pray and pray, hope you get the help that you need. And I want to apologize to the court from the last session we had for my outbursts.
It's okay.
But that's all I have to say. Thank you.
Thank you, Judge.
Did the people wish to be heard?
Just briefly, I don't think there's much of a necessity to be long-winded and follow up those statements, but I think, you know, it's worth saying that those of us, and I say us collectively, the court, defense attorney, victim advocate, prosecutor, those who are in the business of dealing with domestic violence, intimate partner violence, you know, we see the escalation of it all the time, but I think it's so rare to see it escalate to this. Tragedy is not the word. I don't think there is a word, you know, to escalate to such abuse on an intimate partner, and then the kidnapping of a child, and the brutal, unimaginable loss of a child, and then fighting with the police and putting the community at risk and at danger, and just the escalation of such violence in this case and such loss. That I think that this is the prime case where no reduced pleas and life without parole that just fits. It just makes sense. There are a few cases where life without parole on a plea makes sense, and that's this case. And I noted it in my sentencing memorandum, and I thought it was really interesting that the pre-sentence report noted it too, that despite on its face that this is a guilty plea to premeditated murder, life without parole, you know, there's an acceptance of accountability, there is no remorse. So you would think that somebody who had come in was, you know, accepting a plea of this magnitude would be expressing remorse, but the pre-sentence report noted what we have seen from our side of the table as well, is there's very little remorse, and there's very little emotion or acceptance of what the grievous actions of this man and what he's done to so many people's lives. And so there's accountability here, but there's not really remorse, and I think that's really sad, and I hope one day there is. And so we ask the court accordingly to sentence Mr. Trice to life without parole on the count of murder. We would ask, just as the pre-sentence report does, for the top of guidelines on the count of criminal sexual conduct in the first degree. I know it might not matter as much, but the victim in this case, SC, I'm not going to name her because it is a sexual assault, but she is a victim here too. This was an egregious act on her as well, an awful traumatic violation, and she deserves justice as well today, and so we'd ask for top of guidelines on that. Thank you, Judge.
Thank you. Mr. Watson, and you can remain seated if you want.
So I just asked for the permission to use the table. There are a lot of papers and I'm going to be walking back and forth. But thank you.
Yes.
Your Honor, I feel that I've gotten to know a young man who stands before you and is ready to accept his sentence. I can tell you that just last night I received a mitigation report prepared in the federal case. And I discussed this with the Attorney General prior to the hearing this morning. And I know so many people seeking answers as to why this horrible thing was committed. Why Wynter was kidnapped. Why criminal sexual conduct was perpetrated. I'm given the impression, and it gives me some insight, and I wanted to share that with the court. It gives me some insight as to how it is Mr. Trice was raised. I think it was pointed out in some way in the presentation by the people. He was not raised well. He suffers, I get the impression he suffers some sort of attachment disorder that affects his thinking, that affects his understanding of right and wrong, not to the extent that he's not competent to make decisions in his cases, but it affects his decision making. In addition to that, he is apparently mildly cognitively impaired, is the impression that I'm given. This too goes into the overall sense that I've developed of the decision making of this young man. Nothing can restore Wynter's family. Nothing can restore SC. I recognize this. I believe that Mr. Trice recognizes this as well. After all, I don't know what speaks more loudly about remorse than an independent desire to offer his plea of guilt to a mandatory life sentence. He, among many others, will suffer for the rest of his life the consequences of his misconduct. And he's prepared to accept sentencing for that. I can tell Your Honor, and I hope that Your Honor is familiar with my history as an attorney in this county. This is the very first time, and I pray the last time, I would stand beside somebody and let them offer a plea of guilt to something with a mandatory life sentence. I certainly would never recommend this to any client, and I did not in this case recommend to Mr. Trice that he should offer a plea of guilt to a mandatory life sentence. I can tell you that this was Mr. Trice's independent decision making. My team and I prepared to proceed to trial in the case. We worked closely with the Federal Defender's Office as to the approach that they were taking with their case and the approach that we were taking with our case, to coordinate our efforts in an effort to be effective, diligent, and to provide vigorous defenses. This is what we were left with. We were left with this because Mr. Trice independently decided that he would offer his plea of guilt to, in this case, a case that requires, or a count that requires a mandatory life sentence. It was against my advice that we should do this. I stood prepared to try this case. He expects to be sentenced similarly, I believe, in the federal case as well. Our understanding of the agreement, although it's not recited in the pre-sentence investigation report, is that Mr. Trice should serve his sentence in the Federal Bureau of Prisons, and only in the event that he should be released from the BOP, that he would then be transported to the Michigan Department of Corrections. I discussed with Mr. Trice whether he intends to speak. He has most recently shared with me that he does not intend to, but it is his opportunity to do so, and if he wishes to say something, it is his right to do so. Anything that he might say other than that, I would leave to him. Thank you.
Thank you. And now, Mr. Trice, it is your turn if you wish to say anything or not. Was that a no?
Yes, no.
Okay, thank you. I just have to be clear for the record. All right. I really have little to say. I think the victim impact statements, the statement by the prosecutor said it all. And the sentence on count 2 is set by law. I do agree with the sentiment that this is an appropriate sentence in this case. And the sentence on count 2 is not exactly the same as, and count 6 is not the same as far as the mandatory nature of it, but my sentence reflects the seriousness of the offense. It will be within the guidelines, but it does reflect the seriousness of the offense, taking into account the entire transaction and the impact that it has had. So, Mr. Trice, you are ordered to pay $130 to the Crime Victims Fund, $136 in state costs. You are required to register under the Michigan Sex Offender Registration Act and comply with all the requirements of the act. You are also subject to lifetime electronic monitoring should you be released. And on count 2, you are sentenced to the mandatory sentence of life without possibility of parole. You receive credit for 411 days already served. On count 6, you are committed to the custody of the Michigan Department of Corrections for a period not less than 720 months, that is 60 years, nor more than 1,080 months, that is 90 years. You receive credit for 411 days already served. Those two sentences run at the same time with each other. And Mr. Trice, you have the ability to ask the next higher court to look at your conviction and your sentence on appeal. You may also ask for a lawyer at public expense to assist you in that. If you're doing that, you have to do it within 42 days of today's date. There's a form that you use. We will make sure that it gets into your hands. You should just know that the time period starts running from today. And that will conclude this sentencing hearing.
Your Honor, may we reverse the bench briefing?
Yes. No. Okay, that does not conclude the hearing because there was a requested amount in the pre-sentence report for restitution in the amount of $11,300. And my understanding is that the defense has lodged an objection to $10,000 of that for restoration of the alley. I believe that correct me if I'm wrong, but I believe the prosecution understands that legally that's probably not supportable, albeit understanding that that was something they wanted to do.
We understand that we'll make the family aware that we were going to ask for it, but we understand that legally it's something the court is likely not going to be able to order, given that the alley is not something they own or are in possession in. But as far as the funeral costs, the urn costs, and the travel costs for Wynter's father, AJ, for the funeral, we do believe those correctly would fall under what would be legally properly ruling in restitution.
Did you have any objection to that remaining amount of $1,300?
No, thank you.
All right, then that will be restitution in the amount of $1,300 to Almont Smith. And that will conclude the hearing.
Thank you, Judge.
Thank you, Your Honor.